Hello and welcome to Calm the Pharm podcast, where pharmacy business meets legal wisdom, minus the headache. In each episode, we share practical legal tips and real-life examples to help you run your pharmacy with confidence. I'm your host, Sarah Stoddart. Thanks very much for joining us. Today on the podcast, we're talking about the need to have contracts reviewed prior to signing. Lately, I've seen a number of people entering into contracts, signing them, and then providing them to their solicitor for review. Unfortunately, if we receive a signed contract, there is not a lot we can do about it. A signed contract is a legally binding and enforceable document. The point in time at which your draft contract or your contract needs to be provided to your solicitor is prior to signing. In a number of the circumstances I've seen recently where a signed contract lands in my inbox rather than a contract that's still in draft form and capable of amendment, the circumstances are such that the parties involved in the transaction already know each other or are already in business with each other and there's simply a change of interest. However, it doesn't matter whether there is an existing relationship between the parties or not. The need to have the contract reviewed is the same. In fact, where there is an existing relationship between the parties, there's an argument that that is a greater need for review because there may be a difference in bargaining power and there may be a degree of trust which actually blinds the parties from getting proper advice on their obligations and responsibilities and ensuring that their interests are protected. Today, I'm going to give you 3 key examples why your contract should be reviewed prior to being signed. The first one relates to confirming the party details. When we are reviewing a contract, we ensure that the parties to the transaction as named in the contract are in fact correct. That means that you need to marry up the seller's details with the existing owner, and for the buyer, you need to make sure that the details on the contract are in fact reflective of the structure in which the purchaser wants to buy the business or the asset. So whilst that you might have your name on there, it may be that it actually is the intention to buy via a company or trust. Once the contract is signed, if the party details are incorrect, it is a bit of a hassle and does incur costs to get that changed if the change is agreed at all. So the first key thing we're looking for, amongst many other things, is to check the parties to the transaction and ensure they are correct. The second thing we're looking for is key dates. If you present a signed contract, that means the time is already ticking on that document. So if you sign a contract and it's subject to, let's say, 7 days finance approval, but it takes you 3 days to tender it to your solicitor, then you've actually only got 4 days left of your finance period and you've lost key time. We're also looking at the settlement date and assessing whether that is realistic and also whether there is the ability to extend it in certain circumstances and whether that extension is by agreement or unilaterally. That's particularly important with pharmacy businesses where there are a number of components involved in the transaction where a third party has control. So that's your regulatory approval timeframes, your landlord's consent to assignment of lease, etc. We can't control how long that takes, so there needs to be a mechanism in the contract to allow your settlement date to be extended if circumstances are that those things aren't in place by the intended settlement date. Once we have a signed contract, if there is no flexibility around the settlement date, so it's a fixed date, then in order to extend it, you need to get the other side's agreement, and they are not obliged to agree to the extension. So if they don't agree to the extension, you then find yourself in a situation where you're either forced to settle on that particular date, or if you can't, the seller can terminate the contract and you may be found to be in breach of contract. So key dates are super important. The third area I wanted to touch on today is in regard to the conditions and the adjustments contained in the contract. So there are a number of conditions laid out in standard conditions, such as your finance approval. However, when it comes to pharmacies, there are a lot of particular nuances that need to be covered off in the special conditions. And unless you know what to look for and what you need, depending on which party you are, the seller or buyer, it is common that those things are overlooked. And again, if they are not put in the contract prior to signing, you can't get them in there other than by agreement with the other party, and they are not obliged to agree to any amendments to the contract post-signing. There may also be legal implications of making those amendments after you sign, because there's mechanics of how certain conditions work. An example of the kind of adjustments we might be looking for includes not only the adjustments that will be taken into account on settlement, but also things like how the employee entitlements will be adjusted and how customer accounts will be adjusted. When it comes to employee entitlements and customer accounts, they are dealt with in the standard conditions, but that is not always favourable. So we need to look at which side of the transaction you're on, the circumstances of the transaction, and then usually we make adjustments to those conditions in the special conditions, which can't be done if the contract has already been signed. This is just a taste of the things we're looking out for when reviewing a contract pre-signing, and is a reminder to listeners that once a contract is signed, we don't have the ability to easily negotiate or amend these things. Everything needs to be by agreement, and in some circumstances, such as correcting the entity details, it's sometimes the case that the whole contract actually needs to be rescinded and we need to start again, which has a cost imposition on it. But you don't want to be the one bearing those costs, which could have been avoided had your contract been reviewed and your interest protected before you signed. That's all for today. If you have any questions, let me know. Otherwise, I'll chat to you next week.